Welcome to the Privacy Filter, Barnes & Thornburg's briefing on privacy law and policy. Subscribe for the latest updates.
I'm McGinnis. I'm a partner at Barnes & Thornburg located in Indianapolis, Indiana, and chair our firm's data security and privacy practice group. Excited to be on today to talk a little bit about what we see coming up for 2026, the road ahead, in particular for in-house attorneys who are trying to get their heads around all the various privacy laws, and we'll get into some of the AI laws in a second part of this series as well. But figured this would be a good way to end the year to go through some of the things that we need to be thinking about as we head into 2026. I'm excited today to be joined by today's co-host, Lyric Menges, out of our Los Angeles office. Lyric, would you like to introduce yourself?
Sure. Thanks, Brian. As Brian said, my name is Lyric Menges. I am an associate in our Los Angeles office, and my practice focuses on all things intellectual property, data privacy, and technology law. And I have had the distinct pleasure of working with Brian for about 2 years now, and I'm excited to talk all things data privacy today.
Yeah, fantastic. All right. Well, we want to keep these nice and short. So if it's okay with you, Lyric, let's go ahead and get into it. Like I said, today's episode, we want to go through some of the upcoming state privacy laws that we see coming down the pike, comprehensive privacy laws, and a couple others as well. But Lyric, I guess, kick it over to you. Where would you like to start?
Sure. So I think first let's talk about what's actually new in 2026 more broadly. And from my perspective, a lot of companies did privacy around the CCPA, or at least the first wave of laws. And in your view, what is materially different about the 2026 landscape here?
Yeah, that's interesting. So we see a lot of clients who want to check privacy and compliance off of their list. Unfortunately, it just doesn't work that way. I mean, looking back a while, at least U.S. businesses that we work with really had to make quite a lot of changes around 2018 when Europe's GDPR came into effect first, and then again in 2020 with California Consumer Privacy Act. Since then, we've seen more and more states enact new laws. In fact, by the end of this year, we're going to have 20 plus states that will have comprehensive state privacy laws that are similar to the approaches taken in particular by California, also Virginia, and sort of all inspired by the GDPR. So we're only going to continue to see more of these. We don't have a federal privacy law in this country like GDPR in Europe that covers the entire country. And so in that vacuum, state legislators have acted to fill that void with their own versions of these privacy laws. Now, many of you know that. Many of you have been wrestling with that probably for a while. And like Lyric mentioned, you've gone through, certain programs of getting up to speed on these things, getting compliant with CCPA, amending your privacy policy and the like. But because we have so many of these laws now, and because they are all different, we're continuing to see new laws passed that are making new requirements of individuals. This year we'll have Indiana's law, Kentucky, Rhode Island all come into effect, potentially some more as we move forward. And they're all following, similar patterns, things like consumer access to their own data, the ability to delete it, data portability rights, opt-outs for targeted advertising, and those kinds of things. But we are seeing some additional requirements come in. We're seeing, these sort of newer waves of laws are being more strict on things like opt-outs, universal opt-outs, responding to things like global privacy controls, and do not track signals. We're seeing expansion of sensitive data definitions. So things that didn't used to be considered sensitive information, perhaps now may be. So we'll talk a little bit more, I'm sure, about how to identify those and what the additional often opt-in as opposed to opt-out requirements are if you're collecting sensitive data. And we're also seeing a lot more data-specific laws coming about, in particular with highly sensitive information like biometric laws, and then certainly children's privacy laws, and the collection and use of data about minors, in particular that teenage group between what COPPA has historically considered to be children under 13 up to 18, obviously when folks start to get considered adults. So that age, those ages in sort of early to late teen years, we're seeing a lot more activity around there that companies need to get their hands around and understand if we're collecting any data in those spaces that are subject to any of these new laws.
So that's interesting. When you mentioned clients previously and now bringing up companies, let's say I'm in house somewhere and my leadership thinks that our privacy is already handled. Maybe we've drafted these policies ourselves or just did a quick Google search, pulled some language that we think is applicable to us. How would you explain what's changed and why this isn't just more of the same thing that we've been doing?
Yeah. So I talked through a little bit about, there are new laws in this space, and I think we're going to continue to see more laws get enacted. Each time we do, there's some slight wrinkle to potentially some additional requirements or different ways of going about complying with those particular laws. But I think what we are really in the early stages of is enforcement of these laws. Obviously, we've seen a number of enforcement cases come out, but in my view, we're only going to continue to see those increase. And so even if you are dealing with some of these, older laws that date all the way back to 2020, for example, you are still seeing new enforcement of these laws and new priorities with respect to enforcement as technology kind of changes underneath this too, right? So advent of AI and the spread of that is causing folks or regulators to look at the existing privacy laws and figure out ways that they can utilize those to protect against topics that come up that are of concern, like the collection and use of biometric information or teens information with respect to use with AI, for example, right? So in addition to the laws changing, you've also got the enforcement of those laws that I think is really driving a lot of changes. Each of those cases come out, we learn something new about what the regulators want to focus on and the perspective that they are bringing with their role in protecting consumers. Ultimately, these are all consumer protection laws, right? And so utilizing these laws in new ways to focus in on what they perceive to be the biggest threats to data, to sensitive data, and continuing to push companies to ensure that they're meeting the full spirit of these laws. We're only going to continue to see that.
Great. And when you said the older laws, so 2020 era laws, is there a simple way for in-house counsel, for example, to check whether their existing program is still built for a older 2020 world instead of a 2026 world?
Yeah, absolutely. So if the last time you went through any kind of a privacy compliance project was for CCPA or even GDPR before that, almost certainly you're out of date. There's a lot of things that have come about since then that you need to get your arms around that we've been touching on here already today. The good news is I think you can continue to head in that same direction. A lot of the newer laws that have come about since CCPA have really follow more of a Virginia, Colorado model as opposed to CCPA, which is starting to stand out a little bit as a bit more unique. And the newer laws that are getting passed do tend to get to the same points more consistently than previous laws. Although, like I said, there are other laws in addition to the comprehensive laws that are potentially regulating specific pieces of information that make it a little bit more difficult. But I think so long as you are heading in the direction of those original compliance programs, you're trying to understand what data your organization's collecting from individuals, about individuals, what data points those are, being very transparent with users about how that information is getting utilized. How are we using your data? How are we securing your data? And then obviously, who are you sharing the data with? Those kinds of principles that we see embedded in each of these laws remains consistent. And so, if you're thinking about how do we future proof this program, or I guess get as much bang for our buck as we can about the effort that we put into complying with these various laws, I think continuing to head in the direction of those principles and doing what you can to have a genuine conversation with individuals about the uses of the data and the things you want to do with it is really the best way to stay ahead of the laws changing underneath us. So if that sort of becomes the North Star of your program, having underneath that the specific requirements for individual laws that might pop up from time to time, whether it's children's data protection or biometric information, those types of things we've been talking about, and make sure you do have some accounting within the program for those specifics where required, obviously is critical depending upon your business profile and the individuals about whom you have information where they're located. But I think generally the strategy here becomes let's head in the direction of these laws intent and the purposes for which they were passed, which is ultimately to protect people and make sure they know more about what kind of data you've collected about them and how it's being used and shared.
Interesting. So, because of all these new state specific laws that are popping up, I now want to turn to some more common baseline versus new pressure points type conversation and see, in your opinion, what are the common denominators across these new state laws that in house counsel can safely standardize nationally, for example?
Again, it comes down to that notice and transparency piece. What do you collect? How are you using it? How are you sharing it? Making sure that you have good controls with both internally and externally in terms of how those things roll out. So, on the internal side, reducing these things into policy and procedures and processes. So, in other words, how do we, as an organization, understand what data we're collecting across our various teams, whether it's marketing or employment or sales, et cetera. Every organization, every department within those organizations has their own viewpoint in terms of what data should be collected and what they are collecting. So making sure you've got input from all of those various groups are important. So getting a good understanding of what you have, first of all, is critical. And then again, what are the uses of those? And then how are you sharing it? All of those things need to be reduced into written policy. If and when there's some kind of an issue, whether that's a breach or an enforcement action or a lawsuit, having something written down ultimately is your data protection program. So being able to document that is critical. But then those external, those outside pieces, things like data processing agreements, DPAs, with the various vendors and providers that you're working with, anybody who is receiving personal information from the organization, there needs to be a written agreement in place with them that governs that. And there's all sorts of variants in the way that the DPAs can play out. So having someone who knows what they're looking at, taking a look through these DPAs, and not just wildly signing off on them, is really critical to help manage those external uses of data as well.
Great. So it sounds like these newer laws are really pushing companies to change their existing practices beyond just tweaking a privacy policy. And because of that, if I'm trying to sell an update to my executive team, what do you think are the top two or three pressure points that I should be highlighting to get their attention? I know that you mentioned things like the universal opt out signals earlier. Could you speak a little bit more on that?
Yeah, so that's one of the probably newer pressure points, I would say. Understanding that that landscape of the privacy laws is continuing to evolve and making sure that you are keeping up with that in some of the newer areas of those laws, such as opt-out signals, GPC, et cetera. Also, the sensitive data expansion of that definition, the movement towards the requirement for collection of certain sensitive information in some states to be strictly necessary is critical. Another one I'd add is the increased enforcement. So if, they weren't worried previously about having to comply with any of these laws, just strictly from a legal compliance standpoint, I can promise you through both knowledge and experience, quite a lot of experience with clients, that talking with the executive teams about the ways that these enforcement actions can not only result in fines and enforcement actions and things like that, but really disrupt the business is huge and something that they want to avoid. So those are some of the newer pressure points. And I think going back, I think this has been true for a while, even, over the last 5 years or so, let's say. I think consumers, individuals, employees are paying more attention to uses of their data than certainly has been the case historically in this country, and continuing to operate as if it's, 10, 15, 20 years ago when it comes to data protection just isn't really something that's going to fly with most individuals these days. So it's kind of like I tell clients, it's kind of like eating your vegetables. You got to do it. If you're going to do it, you might as well get credit for it. And by that, I mean, if we're going to have to go through all these legal compliance things, why don't we do a good job at it, just like we want to do a good job in other areas of our business or our organization, and put together a good program. That doesn't necessarily have to mean it's the most documented program of all time or going overboard with it. But what I mean is to put together a program that you feel represents your organization, the way that you want to communicate with people, the trust that they show in you, and then tell them about it, right? So have a program that you can be proud of and that you're proud to promote and support. I think really does drive business and trust to companies and to organizations. So in terms of pressure. If you can't get buy-in on this law, this European law, this U.S. law says that we have to do this, which obviously can get kind of boring and doesn't necessarily resonate with every executive. Talking about it from a brand perspective, a trust perspective, how do we drive business perspective, in my experience, can be really effective. So I'd encourage anybody who is fighting the good fight internally on privacy to help push that forward for your organization.
Great. And you said something really key earlier about sensitive data categories, and I want to touch on that too. So, where do you most often see older data inventories misclassify what is now considered sensitive?
Yeah, interesting. So we talked about that a little bit in the sense that some of the newer laws are pushing categories of data into that sensitive category that used to just be considered sort of run of the mill personal information. Why does that matter? That matters because if something is designated as sensitive information, there's more required prior to collection of that information. For example, you may have to get consent from the individual, and opt in, for example, as well, in order to collect that information. So it may be that you have data that was collected prior to the laws sort of redefining what is and is not sensitive information, and going back and performing some kind of an audit to see if any of these types of data are within your systems is key, because you may not have the ability to continue to legally process that. In terms of where we see that most often, I mean, for me, it's more so like internally within HR flows or employment information. So some of these newer categories can get into things like online activity, whether or not you're in a union, information about one's sexual life, those kinds of things that perhaps don't stick out as easily as a credit card number or a social security number are now being recognized, I think appropriately so, as being higher level, more sensitive information. You've still got sensitive information that we've always considered to be more sensitive, things like I mentioned, financial information, biometric information, precise geolocation information, genetic information, those kinds of data types as well. But some of these perhaps softer categories that are in the wrong hands, potentially very damaging to an individual, are now getting also considered as sensitive. So you need to take a look for those. So again, it depends on where individuals are that about whom you have data, where they located. Obviously, that controls which laws are going to apply to those individuals. Having an understanding, therefore, of which laws you're subject to, and getting an understanding, and I guess having the knowledge that some of these sensitive information categories have expanded, and then doing a good audit to understand what data you have in the organization, if any of these kinds of things are the concern, is key. And then setting about making sure you've got all the appropriate controls in place that you're processing this stuff illegally. So, again, where we see it most often is, let's say there was an older HR form or job applicant form or something where you're collecting information that, maybe it's a nice to have, but certainly not a must have. And in a lot of cases may not have been collected with the appropriate consents or notices when it was collected, and making sure that you're not continuing to utilize that data, or putting it at risk, or storing it or retaining it for longer than you need it. That's a good practice that'll help reduce the risk for the organization.
And something that you and I have specifically been working on quite a bit recently, and so I imagine other in house teams are working on it as well. How are these newer teen focused rules changing? And what can marketing and product teams do comfortably in order to address these?
Yeah, we touched on this at the outset, right? So the whole idea of children's data in this country has largely been regulated by COPPA, and considered to be children under the age of 13. And then you've got 18 up who are legally able to contract and are basically treated like adults. This new change of trying to gear more protections to individuals in that mid-teen range is something that has a lot of, I think, public support, certainly political support. You see news articles and stories all the time of teens who are taking some pretty tragic actions over online bullying, over formation of relationships with AI chatbots, like all these kinds of things that can lead to some pretty sad outcomes. And so you're seeing some laws that are being targeted specifically at protecting folks in that age range and requiring more one of the big things that we're seeing drive a lot of this, in addition to laws that are touching on this, are changes with App Store age ratings and requirements there. So, for example, Apple and Google App Stores have having requirements that require more out of the app stores themselves to identify the age of the user, and then assigning that age to the user and passing that information on to the developer. So a lot of our clients are obviously developers of apps that are within these app stores, pieces of software. And historically, it had been acceptable in the U.S. to really draw that line of minors or children at 13, and put in your privacy policy or your terms, this app isn't targeted to people who are under that age. If it's under that age, if you're under that age, it's a violation of our terms of service. You can't use the app. And that was good enough. But the App Store age ratings change is making it such that the app developers now have direct notice from the App Store they can rely on that says this individual is 14 years old or 16 or 17 years old. And there's different rules and restrictions and permissions and requirements for consents that go along with that particular age rating. So the developers are being forced to, in a way that maybe some boring compliance law might not force them, when their access to the app store is dependent upon having controls in place that acknowledge these various ages that are being reported to them, and making sure that they're applying the proper controls and consent flows and parental consent where needed, et cetera, within the app is really critical. And it's something that we're seeing really move the needle for our clients who are developers of that, simply because they need to do so to maintain that access to the app store and keep the revenue flowing.
Absolutely. And that is something that personally for me has been a lot of fun to learn about, is the new App Store Accountability Act and how all of these new age ratings are going to really make a difference, not only for individual consumers, but also on the developer side. And before we wrap this up, I just want to circle back to the overall theme of our conversation for looking at 2026. So, for my last question, I wanted to ask, if you dropped into a company's data map from 2023, what would you immediately relabel or reevaluate under these 2026 standards?
Yeah, well, we've just talked about a couple of them in detail. So anything that potentially is now considered sensitive information, or which always has been and you hadn't labeled it appropriately, that needs to be updated immediately. The definition of children's data, really more minor data at this point, and making sure that you understand how old the individuals are about whom you've collected data. Another key one, those are probably the two biggest ones that I would start with. But that's an interesting exercise. I mean, honestly, most companies, I think their data audits are at least as old as 2023. So not the best practice, but it tends to be something that's really difficult to do. I don't like seeing clients get bogged down in trying to come up with the perfect data map or the perfect data audit. And even if you had one, the second it was done, it tends to be out of date. But having a real understanding from meeting with people across the organization of what data they need in order to accomplish their business goals or their team's goals, having privacy as part of that conversation early on. Do we need to collect this? Should we collect this? How are we going to protect this? Because, oh, by the way, this is now subject to a higher standard than it used to be, for example. Those are critical conversations, and you can't just have that back in 2023 and then never again, or even a couple years later. Everything has too great of a risk of being out of date. So making sure that you're having those conversations regularly, including those people, and keeping on top of the data that's coming through an organization and being sent out of it, really, really key for compliance, and a great way to help reduce the risk as you go forward into 2026 and continue to build out and develop your privacy program.
Well, that's great. And Brian, thank you again. I know I've had fun. I've learned a lot. And as always, it is a pleasure discussing all things data privacy with you. And I will let you close this out.
Yeah, I appreciate it. No, great conversation. Thanks for joining on this, Lyric, and taking part of it. Really fun. These are the kinds of conversations that we have every day with our clients. And I think, as you know well, we really focus in on giving them good, practical, actionable advice that they can take back to their organizations and really help to move the needle and push things forward and put them in a better position to reduce risk, and enable their business teams to do what they need to do to push forward. So appreciate this conversation. As I mentioned, we'll have a couple other episodes coming up. We're going to talk about AI, I believe, in the next one, as well as everybody's favorite subject right now, this California Invasion of Privacy Act, SIPA law. lawsuits and how we can protect our businesses against those. But looking forward to those additional conversations. But for everybody who is still with us and listened through today, I hope this is helpful as you think about how to improve your program leading into 2026. If there's anything we can do to help you out, you know where to find us. Thanks for joining. We appreciate it.